committee welcomes 7-Eleven, who made submission number 64. For the Hansard record, could you please state your names and the capacity in which you appear today?
Good afternoon, Senators. Michael Smith, Chairman of the Board.
Good afternoon, Angus McKay, CEO.
Thank you. Do we have somebody else on the line? Okay, and Mr. Lord?
Yes, good afternoon, Senator. It's Braeden Lord, General Manager, Retail Operations.
Thank you very much. I now invite you to make a short opening statement, and at the conclusion of your remarks, I will invite members of the committee to put questions. Thank you. Mr. Smith or Mr. McKay?
Chair, it'll be myself. Thank you, Chair and committee members, for the opportunity to appear before you today. I will address the claims aired in the media this morning as part of my opening statement. We welcome this inquiry and we are pleased to contribute to its important work. It has been 3 years since widespread wage underpayment was first revealed within our franchise network. Since then, we have learned how prevalent this appalling practice is across the economy and have focused on addressing these issues inside and outside of our network. We have taken enormous steps to remedy the past underpayments and reform our business. 7-Eleven immediately set out, reaching some 15,000 past and present franchisee employees and encouraging them on multiple occasions to submit claims. Without any legal obligation, we have voluntarily paid more than $160 million in underpaid wages to franchisee employees. We have also implemented a comprehensive range of measures across our business, well beyond any regulatory requirements, to raise the bar on compliance. These are detailed in our submission and include centralised payroll, biometric time and attendance systems, a sophisticated data platform, and a significant increase in in-field level investigation and compliance. We have sought to address our challenges from the front and not retire from the debate that was sparked. We also learnt a number of lessons and developed ideas for regulatory reform that we believe will help raise the standard across the sector. These are detailed in our submission, but let me touch on each briefly. 7-Eleven recommends a modification to the termination provisions of the Franchising Code of Conduct and the Oil Code to provide franchisors with the right to immediately terminate a franchise agreement in the case of serious non-compliance with Commonwealth workplace laws or Fair Work instruments as defined under the Fair Work Act, such as knowingly and systematically underpaying workers. Second, we recommend a harmonisation of the relevant termination provisions of the two codes because there is no reason why fuel and non-fuel stores should be subject to different termination provisions and standards of acceptable behaviour. Currently, the Franchising Code permits us to issue a breach notice in the case of serious underpayment. However, provided that breach is rectified within a reasonable timeframe, we are powerless to act unless there is evidence of fraud. The underpayment, breach notice, rectify cycle can continue for the life of the agreement, and we are powerless to act. This not only harms the vulnerable workers who are being exploited, but also harms the many other franchisees doing the right thing, as it potentially damages the franchisor's brand and may erode the value of the franchisee's investment. Our submission highlights our recent experience terminating the agreement of a franchisee involved in the insidious cashback practice. This one termination required us to prove fraud, a significantly higher threshold, and took 18 months through the New South Wales Supreme Court and Court of Appeal. The original hearing subjected 2 former employees of the franchisee to the trauma and anxiety of having to appear as a witness, and 7-Eleven has incurred approximately $750,000 that may not be recovered. The extensive requirements and resources involved in securing such a termination are likely beyond most franchisors. Without the legal power to take action, turning a blind eye may be the more likely approach, leaving vulnerable workers exposed. Our submission also recommends greater disclosure requirements and to ensure franchisee employees have access to information on their workplace rights and mechanisms to confidentially raise concerns. I should point out that, as the committee is aware, 7-Eleven is currently the defendant in a class action proceeding in the Federal Court of Australia. 7-Eleven is concerned to ensure that this process of the inquiry does not place at risk the due administration of justice in these proceedings. However, we will make every endeavour to assist the committee with its inquiries. I'll now quickly turn to the broader franchise sector. We agree with many others that what is needed is not more regulation, but better enforcement of what is already a highly regulated but also highly fractured sector. We would see merit in the establishment of a body such as the Franchise Industry Ombudsman, as suggested by Professor Andrew Terry, to bring together some key educational, compliance and enforcement functions. A franchising ombudsman could centralise and bolster key roles that are currently piecemeal by one, acting as a repository for franchise agreements and ensuring that they are code compliant, providing a register for accredited experts in franchising law, accounting, finance and business that prospective franchisees must call upon in the disclosure process, providing or accrediting training courses for prospective franchisees regarding the risks and the rewards of franchising, and potentially acting as a dispute arbiter. Lastly, let me address the claims of influencing witnesses, again aired in the media this morning. I emphatically reject the allegation. It is utterly false and without foundation. It is a gross insult to the integrity of my team and the franchisees concerned. The claim is made by someone who is the lead plaintiff in a class action against 7-Eleven and therefore has their own agenda. It's this same person who appeared before this inquiry back in June and alleged that 7-Eleven bought the silence of the association leaders that has now also approached us twice in the last month to buy back his own stores. As such, we question the motivation and credibility behind these claims. Not a shred of evidence has been proved or provided to substantiate the claim. Reports of a statutory declaration containing nothing more than hearsay or shop gossip on a chat app defy credibility. The clear facts of the matter provided promptly to this committee with supporting documentation following the claims first being made in June are the following. It is normal business practice for 7-Eleven to buy back franchise stores, with about 20 similar transactions since mid-2015. These negotiations proceed at the pace determined by the franchisee and their particular circumstances. The 5 franchisees referenced in this claim approached us in March of 2018 or even earlier, prior to the announcement of this inquiry, seeking to exit the network. The negotiations were conducted as they normally would, with no regard to timing or matters within this inquiry. The terms entered into with these franchisees contain typical provisions requiring confidentiality of terms and non-disparagement, but do not prevent participation in any regular inquiry, including inquiries like this. In fact, these provisions contain an express carve-out ensuring franchisees may freely participate in any regulatory inquiry without restriction. These franchisees were all legally represented at the time that the terms were negotiated and agreed. 4 of the agreements were finalised and signed on the 6th of June, 2.5 weeks before the Melbourne hearing and before the fact the Melbourne hearing had even listed on the committee's website. With regards to the 5th agreement, terms were agreed before the hearing and the draft transaction documents are nearly agreed and remain with that franchisee for his final approval. We have also informed the committee that another franchisee who was listed for the Melbourne hearing similarly approached us to buy back his store, which we declined to do on his proposed terms. Our actions are inconsistent with the allegations that have been made. These are the clear facts of the matter, fully documented to this committee. In closing, we have made mistakes in the past that led to the underpayment issues discovered 3 years ago. We have sought to be an exemplar in our approach to remediating the past, reforming our business and raising the standard across the sector. We welcome the opportunity to contribute to this committee's important work in this regard.
Thank you very much. Could I just ask who undertook the negotiations with the 5 franchisees that settlements have been negotiated with you referred to?
The process was led by Mr Lord, our General Manager of Retail Operations. Okay,
Mr Lord, could I ask you about the nature of those conversations with the franchisees? 5 have been identified. Is that your recollection of it, Mr Lord?
Yes, it is, Senator.
Right. So could you take us through a timeline of the approaches and the steps that you undertake to achieve these sorts of settlements?
Yes, I can. And I'd like to just take quickly the opportunity just to also reiterate personally that I'm aware of what took place in the media this morning and that I completely and absolutely refute the allegations that have been made. They're simply without basis, and I'm pleased to have the opportunity to be able to talk to them. There are 5 particular franchisees that are in question and have been raised, all of which I've had regular dealings and discussions with over the course of my time within the role, which is approximately 3 years. In relation to the 4 franchisees, they approached me back in March prior to the announcement of this inquiry, seeking to negotiate an exit from the network collectively. We completed those agreements on the 6th of June after what was a very intense and long series of discussions between myself and those franchisees. All 4 franchisees were legally represented at the time and at the time in which the terms were agreed. The terms that entered into with the franchisees contained all the normal provisions, but would not prevent the participation in this inquiry. These agreements contained, as Angus has outlined, an express carve-out that allows these franchisees to freely participate. All of the discussions and the negotiations are part of a standard business practice that when a franchisee looks to exit out of the system and wishes for 7-Eleven to actually acquire or buy back that store, it comes to me for that decision and that discussion. Especially with Bharat, the final person, he approached us back in August 2016, some 2 years ago, to be able to sell his store. And through that period of time, he listed his store, was not able to sell it, withdrew his store for sale, and then again listed it late 2017. And of particular note, early in 2018, in March, he approached me again to be able to look to sell his business. The pace at which the business was sold was really driven by Mr. Bharat and his urgency around some personal situations, which I'm not at liberty to divulge. All discussions were very professional and well respected, as they always have been with Bharat. In mid-June, we agreed to broad terms and drafted the necessary documentation and was provided to Bharat and his legal representation. As outlined, he has yet to execute the documentation, but all terms have been agreed, and he too has an express carve-out that provides him with the opportunity to be able to represent or present at this commission.
Could I ask Mr. Lord, if the 4 franchisees who you finalised agreements with, as you state, on the 6th of June, were leaders of the Australian 7-Eleven Franchisees Association at any point of time?
Look, whilst it was never fully disclosed to us exactly who were the full-time or regular leaders of the association, there were at least 2 of the 4 that were regular features on the committee as we were talking with them about various issues throughout the last 3 years.
So at least 2 of the 4 you understand to have been leaders of the Australian 7-Eleven Franchise Association, and you're not sure about the other 2?
I don't know that for a fact, but I understand that they were, yes.
Right. So that lines up with evidence that we've received that indicated that they were leaders. You can understand, perhaps, Mr. Lord, why the evidence that we received is very concerning, that these leaders received a settlement with 7-Eleven shortly before the Senate hearing, and the remainder of people in that association feeling that their leaders were bought off.
So,
or is it just a coincidence?
Again, I reiterate that we did not approach the franchisees. They actually approached us, and they approached us as early as March of this year to be able to sell their stores. And approached us as a collective. And so as part of our standard process, we walked them through that process, driven by the timelines that they had in their minds, not by a timeline that we were driving them to.
So you're aware of the allegations in today's article in the Sydney Morning Herald by Cara Waters that indicates there's no suggestion that Mr Smith or Mr McKay were involved in the negotiations, but you were actively engaged in the negotiations?
Yes, I was actively involved in the negotiations.
And you have characterised the continuing negotiations with Mr Gonaguntla as almost complete, is that correct?
That's correct. We have an all but final copy of an agreement that is with him to finalise and then return back. And inside that agreement, it contains a carve-out that provides him with the opportunity to provide evidence or provide a personal presentation to this committee. So
you're aware that Mr Gonaguntla did not attend the hearing that we had, was it the 22nd? 8th? On the 22nd of June?
I am aware that he did not attend. I was made aware on the day.
And he was scheduled to appear. Would you characterise the negotiations with you as so intense that Mr Gonaguntla was somewhat concerned about what might happen with his negotiations if he came and spoke on the public record for the Senate hearing?
So I became aware that Mr Gonaguntla was a witness in the days leading into it, as he raised it through our normal course of conversation as we were looking at being able to buy back his store at his request. But at no stage did I advise or lead or encourage him in any particular way. If it was raised through conversation, it was very quickly dismissed, and I provided him with the suggestion that he should seek advice on being able to appear, and that ultimately, as I've stated a couple of times, he did have the opportunity through a carve-out in the negotiations or in the documentation that provides him with an opportunity to be able to appear for the inquiry.
So you do these negotiations and they sound like they're fairly robust. What happens to the remainder of the people who want to sell their businesses?
Senator, if I may I take that question?
Mr McKay.
So we have a practice that we only want people within our network that want to be part of our network. And therefore, if a franchisee approaches us to look to exit the network, we'll look to facilitate in multiple ways. One might be around them putting that site on our marketing sales process, for that site to be made available to other prospective franchisees, and we'll then try to facilitate a sale on behalf of that franchisee. Another alternative, sometimes driven by personal circumstances, sometimes tragic circumstances, is where we will step in and actually work with the franchisee to acquire that store. And the final circumstances might be where a franchisee is in a store that is not making money, where we don't see that it could make money. We'll step in and we'll again purchase that store and run that store to the end of its lease without putting it for resale.
And what is the cost to the franchisees of you adopting any one of those models?
So there's a negotiation.
Because the evidence we've received is that people are walking out with debts hanging over their heads, despite having entered with great hope into agreements with 7-Eleven based on whatever evidence was provided to them by your company about being able to run a successful 7-Eleven franchise.
No, so the process is around a commercial negotiation for that, where we seek to agree commercial terms to acquire that store. Let me go through the individual scenarios. Where a franchisee is selling to another franchisee and that's successful, we will endeavour to grant to the incoming franchisee a further 10 years of term. The two franchisees, prospective and current, would then negotiate a price for that store and transact between the two of them, whereby the outgoing franchisee receives compensation from the incoming franchisee. where we acquire the store directly, so whether that be around us acquiring a store that we might ultimately close or a store where we might ultimately look to refranchise that, we'll buy that store back at a commercial value.
And the determination of a commercial value, how does that happen, Mr. Lord? Because this is a sticking point, isn't it? That the leaders of this association have been able to negotiate, to the best of my understanding, what they considered a reasonably satisfactory settlement, but many others who aren't at the head of that organisation have provided evidence to this committee, some in confidence and by other methods, to let us know that the commercial determination that's been offered to them is wholly inadequate.
Look, the discussions that I've had with the 5 franchisees are no different to normal business practice for us. So as those franchisees approach us, we would work through a standard process of being able to reach a commercial settlement. But given that there are so many different circumstances that actually take place with the franchisees, it's impossible for us to have a standardised way of being able to deal with this, which is where it comes to a common interaction between myself and those franchisees.
So how many of these interactions where there's a sales waiting, how many have you got on the books at the moment you're negotiating with Mr. Lord?
I would have to say it's very few at the moment. I can take it on notice and provide you back with some additional detail.
That'd be great to get the detail, but give me a rough idea, 20, 100?
There's only been 20 in the last 3 years, Senator.
So how many currently? Just a rough number. I won't hold you to it. I'll take your answer.
I would say it would be less than 6.
Okay. So does that include Mr. Gonaguntla, that's 6?
No, I would say that we've reached a conclusion with him, just subject to finalising the documentation.
Okay. So yeah, take me through how's it going, and what happens if there is a dispute about your commercial assessment of the franchise?
So ultimately the process would be that we would meet and talk about the exit of their business and the motivations and drivers behind it. We would understand their own personal situations as much as possible to then be able to gain an understanding about the degree of urgency and in particular be listening to the franchisee about the pace in which they would like to drive the conversation and the negotiations.
So if they're distressed, Mr. Lord, do you give them a low ball offer?
We would work with the offer that they have provided us with and then look at being able to determine a commercial offer that they would potentially also seek, and we would encourage this, to be able to seek a third-party valuation of their particular store as well.
And Senator, if I may, the vast majority of our stores sell on the open market, so this is transactions between franchisees. That's our preferred method of transaction. What I would also highlight, though, is that where we are... Do you
have a right of veto over that? If somebody wants to sell their franchise and they find somebody to purchase it, can you interrupt that process?
So we only have a right of veto over the incoming franchisee, and that's around whether they meet the standards that we expect within our network. We have no right of veto over price. We play an important role trying to make sure the price is fair, that we're not seeing a store transact that would put an unfair burden on an incoming franchisee, but our only right of veto is over the individual coming in.
Excuse me. Yeah. Do you receive an income or royalty for that sale?
So we charge a franchise fee for the issuing of a further 10 years of franchising to the incoming franchisee, yes.
And that's over and above the purchase fee that they give to the outgoing franchisee?
It is.
And what scale are we talking about in terms of dollar value there, Mr. McKay?
It could be, depending on the size of the store, circa $100,000 to $300,000 would be a broad range.
So it's a fairly significant amount of money.
It is, and that fee is effectively the IP that we then license to the franchisee on the incoming basis to operate that store for the 10 years, and the use of the 7-Eleven trademark and all the things that go with that.
So, Mr. Lord, could I ask you on notice and in confidence, because I expect that this is a commercial in confidence piece of information, settlement costs would you be able to provide us with detail of the terms that you finalised with that group of four and Mr Gonaguntla, and give us a perspective of that in context of other settlements that you've undertaken? Because I have concerns that the market price that was sought by these franchisees, that 7-Eleven's gone quite close to what they were asked, but that in other cases settlements have occurred where people were distressed, where they've been offered and ultimately settled for far less than what was considered a fair market price at the beginning of negotiations.
Look, Senator, I'm happy to take that question on notice and would need to seek advice, as I wouldn't want to breach any confidentiality provisions or release anything that may be commercial in confidence.
Well,
I'm sure you appreciate
let's
that.
be clear, Mr Lord. We do expect you to respond to that. That is within the rights of the Senate to ask you for that information. I have indicated, however, we're aware of commercial sensitivities and we would appreciate having that information, and we will deal with it carefully.
And Senator, if I might, for where you are looking for specific examples where people feel that they have not been treated fairly, in confidence, maybe there's a way we can provide some balance to that conversation outside of this public forum.
Yeah, well, we'll look to that. Can I offer the call to Ms Carney? Do you have any questions?
It's been asserted in one of the submissions that more than 90% of your franchisees are from migrant non-English speaking background, and that this makes them particularly vulnerable, and the term easily managed in here because of their English, because of a lack of understanding of the legal frameworks, the industrial frameworks in the country. What do you say to that assertion?
Let me begin with it's a very interesting question. When I became chairman 3 years ago, one of the initiatives that I undertook was to get to know franchisees better. And noting that we had a significant number of franchisees from other places, I undertook to go to the places from which they came and meet their families and understand their circumstances.
And predominantly, where are we speaking about, Mr Smith?
Sorry?
Where are we talking about?
To date, I've been to India, Pakistan and southern China, but I would make the point, Senator, that our franchisees come from many places, and there are others, including Australia, that I'd look at. But, Senator Kearney, it was an absorbing journey of interest that goes directly to your question, and can I give you a sense of how this works? And it's actually the opposite of what you've described, and to me it was a revelation of sorts in going along the way. Migrants, when they come to Australia, and one of the reasons they primarily come here is education, you would understand, and there's a particular vulnerability, I think, about coming to this country to study under the visa arrangement, and naturally enough they seek participation in a community that's familiar with them. In our case, having franchisees that come from this part of the world, they often, through family ties, which are much broader and tighter than we see in Australia, seek to work for a relative or somebody who's from where they come from. The great majority of them, and in my circumstances in every case, were studying here. And then they work in our stores. And then one of the things that you find in that is that they enjoy that participation, and through that knowledge go on and become franchisors themselves, and thus that cycle perpetuates. It's one of familiarity, community and security. And it is in that case surprising to hear these people in those circumstances described in terms that they're easily fooled, that they are taken advantage of, sought out because of vulnerability. They are extraordinarily well educated in the main, in Australian educational institutions, which places significant demands on their English as well. But not only are they well educated, they've also been courageous enough to leave another country and come here. And by the great majority, amazingly resilient people. I won't take the Senate's time telling you some of the extraordinary family stories that go back to the petition and things like that. But they then become franchisors after working in a system. They have an intimate first-hand knowledge of the system and working with people. So while I can understand why the characterisation might be made, my personal experience and observation is it's almost the opposite.
And if I could just add to that, and Mr Lord should do the same, I spend a great deal of my time in stores. I mean, the characterisation that our franchisees lack in education is frankly abhorrent. Most of the franchisees I meet are very bright and engaged people who are looking to thrive in the country that they've chosen as their own.
So what do you attribute the widespread exploitation of employees then? There
are a number of factors all operating at the same time. This is a scandal. It's, I think, a shocking thing that's happened to our country. I think that one of the things that was evidenced by people such as Sydney University that did some work on the possibility of young people having underpayment of their wages is that 4 years ago, for example, I think their conclusion was if you were from somewhere else, it was 84% that were in some form underpaid. And somehow that became normal in our population, and I think in many ways was also a reflection of the limited hours that people coming here to study, full-time study for overseas students becoming such a big part of our community. There was a sense amongst those young people that this is how it was, and there was a reluctant acceptance of it. I think many people that were employing people at that time also saw it as normal. I think it got under many guards, including our regulators, who I think have brought our attention to it rightly. But there wasn't at that time, when we now know for a fact it was going on, people being able to draw our attention to the fact that this had become somewhat normal. As the example we give is if, like everybody's driving on a freeway, it's all doing 100. 100 feels like normal, but the actual speed limit is 80. So I think that it's a collection of those factors.
Characterising this as, replete across the entire economy, that I don't believe is the case. No. So you're saying everybody was under a spell that it was okay to underpay wages. They were educated and enlightened people who just fell under a spell of corrupt behaviours. I
don't think I said that, but if that's I quoted a study by Sydney University, and I think what we've seen.
You also said, Mr. Smith, that these are educated people,
and it's as common as driving a car over the speed limit. So
I'm trying to give you a constructive and honest answer.
Yes, thank you. Well, Mr. Smith, can I just say then that it has been asserted that indeed what you're saying about your particular company is true, that it became the norm for and that you as franchisors were aware of this to the point where it was a bit of a joke because people would go along to training sessions and, jokes would be made like, of course, everybody's doing the right thing by wages, aren't we? And then the whole room would laugh. This is sort of the thing that we are hearing about your company, and that it was accepted as normal by, indeed, 7-Eleven franchisors.
I'm not avoiding us taking responsibility for what we have previously and repeatedly said, that there was, to our great embarrassment and shame, widespread underpayment in our network. And my earlier remarks didn't in any way seek to absolve us of our responsibility for that. Indeed, part of our actions has been to be, if you like, very clear to say that this happened and that we're responsible. I can tell you assuredly that it wasn't a practice that we understood was going on and that we had cooperated in every case with Fair Work when it was reported to. Now, we should have known it was going on, and a number of people in our organisation did know. And I think, sort of what we did was step forward and become, by our own determination, an exemplar of taking responsibility and implied, I think, or imposed significant conditions.
Can you finish your answer, please? We're running out of time, Mr. Smith.
That's all questions. Sorry.
And I'll stop there.
Did you get your answer to your question?
Okay,
I'll give you a
understand.
short answer
That's-
as directly
That'd be good.
as I can, Senator, if you'd perhaps give me the point about which you're most interested.
Really, the point I wanted to make is, did you know as an organisation and encourage and not dissuade people from doing that practice? And
I'm assured that the board did not know, but clearly a number of people in our organisation did know.
Okay.
And we hold ourselves responsible for it and accept responsibility for
So
it.
can I just ask how many claims you are still processing?
I can. So of the original, what we call the wage repayment process, which commenced in September of 2015, there are currently 6 claims outstanding. They fall into 2 classes. That is where individuals have actually been awarded an amount of money, but we cannot contact that individual, and we repeatedly try to do that. And I should say, Senator, that contact is actually done through Deloitte, because we actually don't have any understanding as to who they are. They're just a number from a confidentiality perspective. The second class is where a claim has been awarded, the individual has accepted that, and we're still in contact with those claimants to get banking details to transfer the money to them. There
How
are
many
6
people are we
claims.
talking about?
I will get you the exact number, but it's in excess. It's in excess of 4,500.
4,500 still outstanding.
No, the numbers of claims awarded and paid is in excess of 4,500.
And how many outstanding?
6.
Right, thank you. Senator Williams.
Was it a situation where the profit, in 7-Eleven you share the gross profit, is that correct? The franchisor and a franchisee?
Correct.
So the franchisor pays for all the stock and everything comes in and so on?
And provides the
Okay.
Sorry, Senator, just to be clear, did you say the franchisor pays for the stock?
Yeah.
No, the franchisee pays for the stock.
Right.
So,
So
maybe, Senator, if I quickly tell you what our model looks
Yeah,
like.
make it quickly. How much share of the gross profit did the franchisor get?
So if you have got a revenue line of up to $500,000, we take 50. For the next 500,000, it's at 53%, and for the next 500 and above that, it's at 56%. For that, Senator, the difference between our model and many others, and they are all different, is the cost that we incur and the liability that we hold as franchisor is the lease on the site. We pay the rent on that site, all utilities of that site, all rates and taxes, card fees,
Okay, I've got the
etc.
picture. Have you increased that share of profit to the franchisee the last couple of years?
Approximately 3 years ago we did so.
3 years ago? Was it a situation where the franchisees were forced to underpay wages to stay afloat in many cases?
No, sir, I don't believe that's the case.
You don't believe that's the case?
I do not believe that's the case. Having been fairly intimately involved in, obviously, the operations of the business, what I have seen is that greed is a prime motivator in what was going on. I'm no doubt we will talk about what actions we take now when we see activity in our network, and I can absolutely confirm it is greed.
So
Our process today is
4,500 workers have been compensated, you're saying?
approximately, yes,
What's the total payment of compensation?
$160 million.
160 mil. This first kicked off Alan Fells being the mediator, the bloke in charge of it.
Correct.
Why was he sacked?
We had Professor Fells and Professor Cousins, we should be clear that the 2 gentlemen were involved, did an outstanding job of setting up the process and providing the right proprietary to it. Our core issue with the 2 professors was we didn't believe, firstly, that we should be absolving ourselves of the work that needed to be done to make these payments, and secondly, that they just weren't working fast enough. And the feedback we were getting from claimants was that people were not actually having their claims processed quickly enough and if like, and getting money into their hands. The allegation centre at the time was we did that in order to stop paying money. I think here we sit with $160 million having been paid, and we've proven that categorically wrong.
When you're saying Professor Fells and 2 professors were not working quick enough, wouldn't it have been a case they didn't realise the whole fraud issue was so big?
Senator, perhaps when this happened, we were on fire. And our shareholder...
On fire?
Well, you would imagine what a crisis in the business of discovering this was. And our first act, and I think...
So you didn't call the fire brigade?
Well, I guess we committed to put the fire out ourselves. Our shareholder committed, and what I think is such an important event in this, and said, we will take responsibility for this and we will get people paid. and then we wanted to do that as quickly as we could. And in doing that, they took an uncapped liability to get this paid. Professor Fells was appointed on the basis of getting that job underway and done quickly in a way that people could rely on, I think, it being done accurately. That was the reason that it was being done. We gave Professor Fells a secretariat which protected confidentiality, every encouragement to get it done quickly. I'm sure he would tell you that we were asking to speed the process up. We learned a lot out of the two professors in doing it, and then we came to a point where we had the rest of it under control, enough to say, in the end, people like you will only judge us by what we do, not what we say, and what we do out of our own choice, not what we're compelled to do.
Caltex told us they had a great franchise system. The underpayment was because of greed only, and not that the franchisee could not afford to pay the proper wage. You're saying exactly the same thing, correct?
Oh, so I can't comment on what Caltex said, so I wasn't there.
No. You're saying in 7-Eleven, the reason for the underpayment was greed by the franchisee. It wasn't a case where they could not afford to pay the proper wages. That's what you said?
So in the main, yes, sir. Greed is a major factor here.
Okay.
But sir,
if we get a flood of emails now to the Secretariat saying if we'd paid the proper wage at the time we would have gone broke, what would be your reaction to that?
So without going to the individual circumstances, I couldn't react to that. I can only really say all I can talk to.
Isn't it a case of because of all this, you've actually increased the profit share to the franchisee?
Oh, we've done a number of things because of what we
have you increased the profit share to the franchisee?
We have.
Why?
Because we wanted to ensure that the circumstances we found ourselves in could never happen again, that no one could ever lay at our doorstep, that these entities did not make money.
That circumstance infers to me that the franchisee was not making enough profit to pay the proper wage, and you've increased their profit consequently. Does that make sense in what I'm hearing?
Sir, it is all about the notion of making sure that the entire set of business circumstances were being catered for under our model.
Can I ask a question now? Can you guarantee that every person who's working in a 7-Eleven store across the country now is receiving legal wages?
Senator, in terms of
because I'm sure you wouldn't want to go through this process again. No? I'd like you to be able to tell me that you can guarantee that, Mr McKay.
So, Senator, what I can guarantee you is firstly that we pay people because we run a centralised payroll based upon the hours reported, and that we audit those hours, and I'm happy to go into those details, and that therefore the payroll that we provide directly to the employee is correct.
So I've got one last question, Chair. Oh. So here's my problem. You're saying the underpayment of wages was due to greed by the franchisee, and that the franchise system you've set up is good and viable and can afford to pay all the bills at a proper rate, rate of wages. Then the next thing you did was increase the franchisee's share profit. That infers to me that if it was all honky-dory before, why did you increase the share profit? Or were you realising that perhaps they could not afford to pay the proper wage?
I don't think, Senator, I understand your point. It's a good question. I don't think this is a series of absolutes. There are a number of problems, and I think it would be fair to say that there was some element of our model for low-volume stores that didn't provide a small volume store with enough profit, enough financial resources.
Enough gross profit to pay their wages properly.
Well,
that's in contradiction of what
No, I think I'm trying to provide you with more detail rather than avoid your question. Mr McKay said, and I agree with him, that in the main, but I don't want the information that you're seeking to go unattended, and that is to say that for a low-volume store, I think it was fair to say that there would be a challenge. Now, if you look at the problem overall, we don't accept that the amount of profitability in the system caused this, but in a minor set of cases for these, that's why we've introduced a minimum guarantee, and that we never want to go back here again, so that we have ensured that there is a level of income, regardless of the performance of the store, the franchisee is being assured to get. I think that's probably unique. We also now take, and going to your question, Senator O'Neill, we now take responsibility for the payroll being managed. So previously, while the franchise...
We've legislated that, basically.
Well, before any of that happened, Senator, this goes to your question about increasing the amount of gross profit. Our agreement did not allow us in those times to insist that the payroll system run by the franchisee, which is where the underpayment occurred, 7-Eleven corporately has never underpaid anybody. So the franchisee could, at their own discretion, choose to run their own payroll, which I think you heard about in earlier evidence, in order to get the franchisee to sign a new agreement which handed total control to us for running the franchisee's payroll system. We, if you like, needed to provide an incentive to do that. And part of the reason that you would see us paying franchisees more money in the split that you've described was part of a bargain at that time, and Mr Lord was instrumental in it to get our whole system over to a new arrangement, which has now got a comprehensive sets of checks and balances, including biometric sign-on, algorithms that test it, a compliance team, whistleblower services, and we would offer that up to the rest of the system as an example of going to where you're going, Senator O'Neill, is that you would have to be extraordinarily creative and deceptive to beat that regime to ensure that wages are paid.
So is it possible that people could be, franchisees in your system could be putting in hours that are incorrect for people who are working for them? Is that possible with the system as it is?
I don't think it is. I'll ask Mr McKay to give you some of the detail of why that's the case.
Do you have facial recognition?
So we are literally 3/4 of the way through implementing facial recognition across our network. We have a biometric time card system, whereby an employee or anyone that is store thumbs in, thumbs out, that records their moment of start, their moment of stop. We reconcile that back to CCTV at the moment. That will then change to facial recognition once it's fully implemented. And we reconcile that back to the timesheets that are ultimately what the payroll is provided to the employer.
And have you had any whistleblowing by employees within your stores to let you know that there are practices emerging again that are taking their wages away from them?
So Senator, I would say we have. And
by what method this time?
So
if I could, around the corner and pay me back the cash?
So if I could just firstly, so over the course of the last 2.5 years, we have terminated some 18 franchisees, and that is for underpayment. In the main, those have come from whistleblowing activities out of our
So how does it work now? With all the new systems in place, people are still doing this underpayment. How's it working now? What's the new game?
So I won't say it's necessarily a new game, Senator. The example I gave you of our New South Wales court activity is that game, which is this insidious practice of cashback, which is someone receives the right amount of money either into their bank account or sometimes in cash if it's required, and then they are asked to go somewhere else and hand back a proportion of that money.
And was that what happened in the 18 cases where you've dismissed franchise?
I'd need to revert on that, but I would suggest that is the main reason that is occurring today.
Right.
And is that still happening out there?
Occasionally it does so, yes.
When was the latest report of that?
So if I go to the end of that, we terminated 2 franchisees for that practice in July of this year.
So it's still alive and well?
Unfortunately,
in some practice, yes.
In some aspects it is. Senator, the challenge that we have here is, it is not necessarily our power. This is happening behind closed doors, out of our eyes and earshot. What I can guarantee you is that when someone raises their hand that it's going on, we investigate and chase that down.
And what sort of time frame does that take?
Sometimes that can be days, weeks or months. It depends on, unfortunately, the individual being quite frankly brave enough to put their hand up. Mm-hmm. I talked to the 2 individuals that helped us secure the win in New South Wales. We would not have had that win in New South Wales had those 2 not been brave enough to, 1, put their hands up, but 2, follow that through over what was ultimately an 18-month process.
And do you provide some compensation to them?
We ensure firstly that they are paid correctly, so we make sure that there's restitution for the amounts that are, if you like, taken from them. Secondly, we seek to guarantee them increased or guaranteed employment through maybe our corporate network.
Is there any
but
incentive?
Our prime objective is keeping them anonymous.
Is there any incentive offered to whistleblowers to contact you?
Is there
any incentive offered to whistleblowers?
Only that we will react and try and, if you like,
so
eradicate.
No payment for them.
There's no payment. That we don't make payment for people whistleblowing. No.
Senator, if I may, in the work of your committee, one of the things that was really disappointing to us is the silence of those people that were victims of it. And we're doing all we can to make whistleblower working, but in part of your consideration of this system is to facilitate whistleblowing however it occurs and the protection of the whistleblower. I think it is an entirely healthy system, and we are still deeply concerned about the fact that for whatever reason there's not enough, I guess, ability for people or
this
comfort.
Committee did deliver a unanimous report to the government about whistleblowing with recommendations around internal and external whistleblowing options to increase people's confidence in coming forward. That hasn't been responded to yet, so we're hoping for that to happen soon.
But they were scared of getting kicked out of the country for working more than 20 hours as students. That was the biggest problem.
More power to your arm.
We understand the circumstances and completely support where the committee has gone to. Just because we do have whistleblowing lines that are both direct into ourselves, but for those people that don't want to make their names known to us, there are third-party confidential lines that they can also take advantage of.
Excellent. Can I ask again, Mr. Lord, if you could give me an outline of the dates of negotiation with Mr. Gonaguntler and the other four franchisees during the period of May and June earlier this year. What offers were made and what quantum? On what dates?
Okay, so I will need to take that on notice and provide that back to you post seeking counsel just on the quantity and the timetable I've certainly got available.
Were there significant increases in the offers made to the 5 franchisees who were seeking to sell to you? Were there significant increases in the amounts that you offered over the course of the May-June period?
The conversations were absolutely driven by the individuals, not by myself on timetable, and there's no correlation between the amounts and the timetable that you're outlining, Senator.
Did the purchase offers increase in the period of June? This year?
I would need to take that on notice, but certainly I can say for the conversations that I had with Mr. Barath, that did not take place, and I am almost certain that that is the case with the other 4 franchisees as well.
Did the offers decrease?
No, they did not. They all reached the tail end of the conversations by the time we were made aware of the hearing coming up. I think the key point in all of this is to just pull us back to the core motivation behind this, and the conversations that were taking place were that right back in March for the 4 franchisees and 2 years ago for Barath, is that that's when the process started. So the fact that they approached us looking for an exit out of the business, we worked with them closely to be able to facilitate that for them.
I'd like to understand the trajectory of your negotiations and the amounts of money that were offered at different points of time. Can I go to Senator Ketter?
Yes, thank you. Now, with the Franchisee Association, Mr. Lord, I take it you're the one that has the most contact with them. Are you still dealing with the leadership of that association?
Look, we deal with all franchisees very equally on the way through, and that includes absolutely the association and its members. And
who are the current leaders of the association?
That I could not answer at the moment, because my understanding is that has not necessarily been filled on a national basis. I can provide you with some names post this for those that we're aware of on a state basis.
Okay. Now, do you have an internal dispute resolution process for franchisees?
I'd like to refer to Angus for this particular question, if you don't mind, Senator.
So we have quite a detailed process that franchisees get to avail themselves of. It starts off with their regional business contact, which is...
Happy with that answer. Can you tell me whether there's a role for the Franchisees Association in that process?
My instinct is no, from an association perspective. My belief is that where a franchisee has an individual issue, that we should be looked upon to manage that with them, and where they can't get satisfaction with ourselves, that they should avail themselves of mediation processes, whereby they are represented for themselves, not represented necessarily by an association. Should they choose to have, for instance, in a mediation, the association, for argument's sake, as their representative, that would be absolutely fine by ourselves.
So you'd require them to go to mediation before they could be represented by the association?
Well, I wouldn't say required to. That's really their choice to go through to that ultimate point. And I think that is the ultimate point.
But you won't allow them to be represented in the internal process?
Our preference would be to deal directly with the franchisee.
Now, just coming back to Ms Carney's questions about the composition of the franchisees and the allegation by the Franchisee Association that 90%, or sorry, more than 90% are migrants from non-English speaking countries, especially India, Pakistan, China, Bangladesh and the Middle East. I'm interested in the factual situation. So can you tell me, as at August of 2015, the time of the Four Corners program, what was the composition? Was it 90%, 95%, 100%?
Senator, I couldn't tell you as of that date. I can endeavour to go back and get that detail.
Why can't you tell me that?
Well, firstly, I wasn't there at that particular
I'm sure
day.
you've got records, Mr McKay.
But Senator, I don't have those records in front of me, and I certainly
don't
have
I'm
them
not
on
asking
memory.
right now, but I'd ask you to take that on.
I'm Senator, happy to go back and actually look and bring it back on notice.
Please go back and look at, as at August of 2015.
August 15.
And I'm also interested in the current situation.
Understood.
So the composition. So now, can you tell me what changes you've made to your system since the introduction of the Protecting Vulnerable Workers legislation last year?
Well, specifically with the introduction of that, none. Our changes were made prior to that occurring, and I would argue that the changes that we made prior to that Act being brought through Parliament actually keep us above the requirements of the legislation today. You know, as the Chairman has said, on a first basis, we provide all payroll services directly into our franchise network. We have tools that actually allow franchisees to simply record their time cards. We then monitor that and audit that on an ongoing basis. We ensure that the amounts paid to franchisees are compliant with the acts and the awards that are paid there, let alone any EBAs that might be in our particular network. We provide services back into employees around their rights, their rates of pay, give them hotline access, as I described earlier to the Senator. And equally, we then work specifically with franchisees, specifically around their obligations to pay according to the Fair Work Act, around the rosters that they run and manage on a daily and weekly basis.
As at August of 2015, can you tell me, and you might want to take this on notice, but what proportion of franchisees were having their payroll done through your centralised system?
Again, I'd take that on notice, Senator.
Was it a significant, very high percentage?
Again, I'd be just completely guessing back then. I can tell you now it's 100%. I couldn't tell you, but I will come back.
Right.
Okay. Yes, Ms Carney?
Are you an accredited franchisor for the purposes of banks?
We do have accreditation with banks, correct, Senator?
Yes. Do you get any benefit at all from being accredited?
I suppose the one benefit is if you like, it simplifies the approval process for an incoming franchisee. Mm-hmm. There is no financial benefit to us for that in any way, shape or form. Okay. But by the bank having taken the time to get familiar with our model, our audit practices, the standards that we expect franchisees to play to, provides them with an ability to immediately deal with the franchisee who's coming in rather than get familiar with our system.
Okay, because I did note in one of the submissions that one of the franchisees had been refused lots of loans but was given a loan by the ANZ, and he was rather surprised at the amount that he was given without much, investigation into his circumstances. Are you accredited by the ANZ?
So the ANZ was an accredited borrower, certainly a number of years back. As to how ANZ or any other bank goes about its lending practice, that's between themselves and their prospective borrower. But from our perspective, our benefit is purely trying to make this easy for a franchisee coming into the system. There's no financial benefit to us at all.
How many banks are you accredited with?
I believe it's 2 today.
Which are?
So the National Bank and the Bank of Queensland.
And have you ceased your accreditation with ANZ for any particular reason?
It's not a matter of having ceased. The ANZ still lends into our network. I can't remember whether we're accredited by them or not.
Could you take it on notice and give us any indication of why you might have changed that relationship? Can I just ask a question about the thumbprint that you indicated? Is that a unique identifier for each employee, or is that just for the store owner?
No, that's a unique identifier for the employee and also for the store owner as in individuals. So we have an expectation that anybody that works behind the counter in one of our stores will thumbprint in and thumbprint out.
Are you confident that there's no way for the system to be rorted?
Oh, I wouldn't say there's no way. That would be, this is the 21st century, people find ways around most things. I am confident around the reconciliation process we go through to validate that the times, if you like, accredited to the thumbprints match the hours that are being worked by people.
Okay.
As I said just a few minutes ago, we do that today via reviews of CCTV, and we will ultimately do that via facial recognition.
People knew what was going on inside 7-Eleven. You indicated that in your evidence earlier. The chairman and the CEO both stepped down. How many other people were dismissed?
We haven't dismissed anybody. Those individuals did step down. The process that we undertook within our organisation was to set about fixing the issues rather than looking to attribute blame to what was clearly an insidious practice.
So you still have all the current staff, the same staff, who were in place at the time?
Staff have turned over quite considerably. For instance, my executive team would have 60% of those individuals are new to the organisation since, if you like, before I started.
But you didn't ask anybody to step down?
I didn't know.
No. Did anybody in your organisation take responsibility for identifying people within your organisation who were facilitating wage fraud, and were they dismissed because of their action? Did anybody do that?
So, Senator, as I said, I did not do that.
Senator...
Yes, did anybody do that?
Specifically, no. In what you're describing, so that's the short and direct answer. If we had direct evidence of it, we would have acted. I think we've got now 4 new board directors. We've got a new chairman. We've got a new chief executive. We've got a new head of retail operations. 60% of the executive group is new. We've taken $160 million worth of cost. So our response to it, I think, is comprehensive. But no, I'm not avoiding answering your question, no.
But Senator, also just for the record, in terms of where we are today, if such a practice was ever to be discovered whilst I'm CEO, that would be the case. We would be terminating people.
Thank you. Just the last question for you, Mr Lord. Did I correctly hear you when you gave evidence earlier that you finalised your agreement with a group of 4 on June the 6th this year?
That's correct. So finalised them after several months of negotiations on the 6th of June.
Right. Now, there were 2 names in today's article by Kara Waters, Mr Sunil Singh and Mr Kevin Patel, who were indicated as leaders of the association. Were either of those gentlemen amongst the 4 that you finalised that arrangement with?
Those 2 were part of the 4 franchisees that we finalised negotiations with.
Okay, this is concerning to me, Mr Lord, because I am aware that the Senate was in contact with the leaders of that organisation on or about the 5th of June, the day before you reached your settlement.
So,
is that just a coincidence?
Senator, at no time did I have discussions with the franchisees related to this agreement about their attending or appearing at the Commission. And in fact, we went right back to the March when we started these negotiations before there was a hearing likely to take place. And it was driven out of the fact that the 4 franchisees wanted to exit the system, and they approached me as part of standard business course. They also have the ability in the documentation to be able to, as an express carve-out, to be able to come and present to you should they wish to.
Right, so there's documentation that says, from your point of view, Mr Lord, that there was no dissuading of people coming forward to give evidence, but the fact is, after 3 months of negotiations, you finally settled with at least 2 of the 4 in the group on June the 6th, and they had been contacted in the Senate in the day preceding that. That is simply a coincidence. Is that the case, Mr. Lord?
I was not made aware of their contact with the Senate or with the Commission and with this hearing, and so my discussions with them were about facilitating an exit for them out of the system. Thank you, Senator.
Does the agreement involve the payment of future sums of money?
All of the exact amounts of money were negotiated as an upfront, but there is, in fairness, and I understand that there's documentation that you have on file about the specific agreement with certain redactions, but the timing does have a holdback of 9 months.
And are those future payments discretionary to the company?
No, they are not. The future payments are largely work through around ensuring that there's a high level of confidentiality between the parties around the terms of the exit, and that's what it relates to.
And Senator, if I could just add one thing, the 6th of June was the date that the agreements were executed. The documentation was with their respective lawyers for a period before that, which we're happy to take on notice to give you that timeline as requested, but the documentation was well with their lawyers well prior to the 6th of June, which was the execution date.
But if these future payments are contingent on confidentiality,
Then they're discretionary.
then it's up to you to decide whether they've maintained their confidence or not.
Is that correct, Mr. Lord?
So they have the ability to be able to present and to talk at this commission, and there's a specific carve-out related to that. So the holdback or the retention amount has no bearing on that.
So you say, Mr. Lord, but they resigned as leaders of this organisation and they didn't show for the Senate. It seems to me passing strange that all this is happening within a period of like 48 hours.
With a discretionary payment.
With a discretionary payment hanging over the top of their heads.
Senator, if I may, go on, Braeden.
I was probably at risk of just repeating myself in that this is very standard practice for us to be able to work through these negotiations, and all of this with the 4 franchisees was driven out of their timelines and their wish to be able to exit the business, and we were pleased that we were able to facilitate that to them based on their own personal situations.
Senator, in your place, we'd be asking exactly the same question. I appreciate why you're asking it and why you would be, if you like, questioning it to the degree to which you are from our side. We regret that the timing looks like it does, but this is very much business as usual. But
that's not exactly reassuring for me, given the reputation of 7-Eleven in recent times.
Well, let me finish if I may, but I understand, is that the amount of agreements reached over the last 3 years has been of this type have been about the same every year. The terms about which they've been agreed look the same. These franchisees approached us with a timeline that goes back some time, and the time for completion was driven more by them than us.
So, Mr. Smith, can I press on you that we want a really clear indication of the type of negotiations, the numbers that were involved, when it went up, when it went down with these people?
I understand.
Because we want to hear a story that's different to the one that it looks like it is.
Completely understand.
Because we'd like to think people are getting a fair deal when they're exiting 7-Eleven. And I guess I'd like to put on the record too that, you know, anybody who goes and buys something from 7-Eleven, maybe you need to ask if they're getting their fair pay.
And could I add to that? And if they are not, I would encourage them to come to us, because we will make sure they do get their fair pay.
And that whistleblower line is available for people, the members of the public, to
It
put
is indeed.
concerns up to you as well.
Correct, and it is found on our website.
Good.
And you want to tell us what it is now?
Oh, off the top of my head, I wish I knew the number, but Senator, I will take that on notice and I'll make sure you have it.
All right. Thank you very much. The committee will take a short break and return at 3:25.
Okay.